I want everybody to know that I normally don't start until the ranking member's here, but I can go ahead because of other things that she's going to be doing for a while. Judge, we're starting out for third round. As I said, I hope everybody can not exceed 15 minutes and hopefully shorter. I want to lead by example for how much time I take. It'll be a lot less than any of that. I'm going to ask you, Judge, about a dozen questions that really you can answer yes or no, and then I'll yield back my time. I want to give you a hint that all of these questions can be answered by yes. In Ute Indian tribe, am I right that you held that a country's prosecution of a tribal member for action taken on tribal land caused irreparable injury to tribal sovereignty? In Fletcher versus U.S., did you rule that members of another tribe had a legal right to demand an accounting from the Secretary of Interior for funds the government held in trust?
Yes.
In Cook versus Rockwell, did you rule that plaintiffs had the right to pursue tort claims against a nuclear weapons manufacturing plant for committing environmental crimes?
Yes.
In United States versus Magnesium, did you reinstate a lawsuit against a corporation alleged to have violated anti-pollution laws?
Yes.
In Energy and Environment Legal Institute, did you uphold a Colorado law requiring that a certain amount of electricity sold come from renewable sources?
Yes.
In Orr versus City of Albuquerque, did you hold that the pregnancy discrimination claims of two female police officers deserved a trial?
Yes.
Did you, in two cases, affirm finding by the Department of Labor's Benefit Review Board that retired miners were entitled to black lung benefits from their employers?
Yes.
In Casey versus West Las Vegas Independent School District, did you hold that a former school superintendent could take her claims for retaliatory discharge to trial?
Yes.
In Crane versus National Science Foundation, did you hold that an academic employee had been wrongfully terminated from his university position without appropriate findings of fact?
Yes.
In Browder versus City of Albuquerque, did you deny qualified immunity to police officers who wrongfully arrested a 7th grader for making fake burps in a gym class?
I voted that way, yes. In AM, yes, versus Holmes.
In Blackman versus Sutton, did you deny qualified immunity to staff at a juvenile detention center for using a restraining chair to punish a pretrial detainee?
Yes.
Those are just a few examples of cases where you've ruled in favor of what I would call the little guy. But I have one last question. I think that whether you rule for or against the little guy or the great big guy is not the real question. The real question is whether you apply the law faithfully. Would you agree with me on that point?
I can tell you I tried my best.
I yield back my time, which will be 11 minutes and 33 seconds, and encourage my colleagues to do the same. Senator Durbin.
Thank you, Judge. We've asked previous nominees for the court about their experience in private practice in the pro bono work that they've done. Could you tell us briefly what pro bono work you've done as a private lawyer?
Oh, gosh. Senator, over the course of my career, it'd be varied. At different points in time, different things. As a judge, I've done a lot of work on the Rules Committee. I've done a lot of work trying to make litigation faster and cheaper, together with colleagues. I don't deserve a ton of credit. We work by consensus on the Rules Committee. The Capital Habeas Project, again, was a collegial effort. Before that, I would point I spent time at the Department of Justice. That's not pro bono work, but it's public service. As a private lawyer, we did all sorts of different things. We'd modify our fee arrangements. We do contingent arrangements. We waived our fee arrangements.
Did you ever represent, either pro bono or otherwise, an unpopular or notorious client?
I would think a lot of my clients would have been considered unpopular, Senator. And notorious is in the eye of the beholder, but certainly people who are accused of crimes, people who are involved in what might be considered scandals. Yes, Senator, without revealing any attorney-client information, yes.
I want to ask you about an email you sent at Justice. The subject line was Elite Law Firm Pro Bono Work for Terrorists. And you included an article about conservatives criticizing lawyers who were representing Guantanamo detainees and a list of their law firms. You sent this email to someone working on this committee, and you said, quote, I thought you might find this of interest. It seems odd to me that more hasn't been made of this. See especially the list of firms below. This was one of several emails you sent criticizing and drawing attention to lawyers representing Guantanamo detainees. Chief Justice John Roberts, when he appeared before this committee, was asked about the fact that he'd represented some unpopular clients and said, here's what he said, our founders thought they were not being given their rights under the British system to which they were entitled, and by representing the British soldiers, John Adams helped show that what they were about was defending the rule of law and not undermining it. And that principle, that you don't identify the lawyer with the particular view of the client or the views that the lawyer advances on behalf of a client, is critical to the fair administration of justice. So, for the record, would you put in perspective any comments that you made about people representing Guantanamo detainees?
Senator, my friend Neil Gorsuch, who introduced me, successfully represented some of those detainees. And I have nothing but admiration for those lawyers. And the email you're referring to is not my finest moment blowing off steam with a friend privately. The truth is, I think my career is better than that. And when I've seen individuals who've needed representation as a judge, when I've gotten handwritten pro se filings, and I've seen something that might have merit in it, I picked up the phone and I've gotten a lawyer for that person. When I've seen lawyers who are not representing even undocumented aliens appropriately, I've done something about it. So I'd like to think that my career taken as a whole, Senator, represents my values appropriately.
Thank you. Thank you, Judge. Thank you, Mr. Chairman.
Okay. Senator Flake.
I yield back the balance of my time and encourage my colleagues to do the same.
Okay. Senator Whitehouse.
Good luck with that.
The chair did not encourage him to do that, but I surely didn't discourage it.
Well, let me start by paying a compliment to our chairman. I think that he's handled these hearings in a very gracious way. He's given us a great deal of time and leeway, and whatever our opinions might be about the suitability of the nominee, and obviously that's as yet undetermined for many, I think we can agree that the chairman has done a thoughtful and good job, and I appreciate the way in which this has been managed. Judge Gorsuch, this is probably the last time you will pay attention to me.
Don't count on that, Senator.
I'm not likely to appear before the court unless things should change fairly dramatically. So there are just a few things
Now, that would be interesting. You know, I've had Senator Lee in my courtroom.
Yeah, and I've argued in the Supreme Court, but some time ago. I wanted to tell a story to you to follow up a little bit on our conversation where I was trying to draw an analogy between anti-competitive controlling economic power and anti-competitive controlling political power. I was elected to the Senate in 2006. I was sworn in 2007. For the first 3 years that I was here, 2007, 2008, and 2009, there was constant Republican activity on climate change in the Senate. During that period, the Republican candidate for president even had a robust climate change platform. And there were probably 4 or 5 separate bills that had Republican co-sponsors. I was on the Environment and Public Works Committee where Senator Warner, John Warner of Virginia, a Republican, had a bill. Senator Susan Collins had a bill with Senator Cantwell. Senator Alexander had a bill. I think Senator Graham was even working on one. There were a considerable number of them. We didn't have agreement on that issue yet, but there was activity. People were talking. The legislative process was going forward. The Citizens United decision was decided in January of 2010. The fossil fuel industry asked for that decision to be rendered, expected it to be rendered, and moved incredibly rapidly to take advantage of its new opportunities. And from that moment forward, there has not been a single comprehensive piece of legislation with a Republican co-sponsor related to carbon dioxide emissions. That industry is defending, according to the International Monetary Fund, a $700 billion a year subsidy. So the amount of weight they can throw behind trying to stop any effort to interfere with their current status quo goes beyond almost any reasonable number to spend in politics. So just bear that in mind as you go forward, that, in my view, Citizens United did not expand debate in the public sphere, particularly on that issue. It actually allowed powerful special interests to squash public debate, and I think the conduct of the Senate proves that point. So take that for what it's worth, but I think if you look at it at some point, you'll find that what I'm saying is accurate. The second thing that I wanted to touch on is the jury. A great number of the decisions that I listed in that 16-0 corporate versus human 5-4 array that the Supreme Court has decided recently had the effect of limiting access to a jury. Did it with raising pleading standards, did it with limiting class actions, did it with encouraging mandatory arbitration. To me, the civil jury matters quite a lot. To the founders, it was one of the casus belli of the revolution. They took it terribly seriously. Hamilton described it as one of the absolute pinnacles of what we needed. Adams described the popular vote and the jury as the heart and lungs of liberty. So this was a big deal. De Tocqueville described the civil jury as a political institution. He meant that in the best possible way. It was part of our polis, part of the way in which the public had the chance to participate in making decisions. He called it part of the sovereignty of the people. Blackstone, who was probably the single jurist who most educated the founding generation, said that the civil jury is what prevents the encroachment of the more powerful and wealthy citizens. So you have a constitution, a great deal of which is dedicated to protecting the individual from the power of government and the power of the state, and to dividing up the power of government and the state so it does not unify and crush individual behavior or dreams or wishes. This institution is the one that was designed to protect the individual against other more powerful and wealthy citizens. And in this world, our most powerful and wealthy citizens are these ginormous corporations, ones that collectively in the fossil fuel industry enjoy that $700 billion per year subsidy. So I would urge that as you consider this array of cases that chips and chips and chips and chips away at the civil jury access that regular Americans have, particularly where it involves big corporations, because they're the ones who can force mandatory arbitration on people, for instance. They're the ones who tend to be the victims of class action suits, for instance. That you bear that in mind. Are you sensitive to that so-called political institution of the civil jury, and do you agree with me that it has a role in defending the little guy against the more powerful and wealthy citizens?
Senator, I've talked a lot about the Seventh Amendment over the last 3 days. Quite a lot. I'm a believer in the civil jury system. And I don't know whether it's the very bulwark of liberty or the palladium of liberty.
You've got the Hamilton quote. Good for you.
All right?
Yep.
They debated that.
Yep.
Which one it was.
Yep.
But I'm a big believer in it. I spent a lot of time in the trial trenches of the law. I saw the value of the jury system. And yes, Senator, I'm a big believer in civil juries. And I think my record proves it.
Stick with it, because it's going away unless the judiciary breathes a little bit of life into it. And at the moment, I think the Supreme Court is leaning the opposite way. The last thing I want to ask you has to do with an email that you sent back in some time ago, but I think you'll remember it, back in February of 2006. The scene was Attorney General Gonzalez's testimony to this committee with respect to the terrorist surveillance program.
Okay.
It was the testimony that led to Department of Justice Inspector General investigation. And I have the declassified version of it here, which found that the Attorney General's testimony was incomplete and confusing, and that it was confusing, inaccurate, and had the effect of misleading those who were not knowledgeable about the program, which was obviously all of us, because it was a classified program and we had not been read into it. On this day, when the Attorney General of the United States was giving misleading, confusing, and inaccurate testimony to this committee, you emailed back to Kyle Sampson and William Maschella. I think the AG is doing a really nice job today. He's running circles around the committee members. Now, running circles around the committee members worries me a little bit in the context of testimony that proved to be incomplete, misleading, inaccurate, and was criticized as such by the Inspector General of the Department of Justice. Do you recall when you sent that memo what you knew about that testimony and when it was that you came to realize that Attorney General Gonzalez's testimony was inaccurate and misleading to this Senate committee?
Senator, someone shared that email with me this morning, and I looked at it. I don't have an independent recollection of it, sitting here 11 years later, whatever it is. And to my knowledge, I did not have any classified information at that time.
I gather that you did help him prepare that testimony.
Senator, I did, as a speechwriter, work from public materials.
As we know, Director Comey and others subsequently testified to all of the drama that surrounded that, which was the subject of why, that was the reason that this was misleading and inaccurate. There was the confrontation in the Attorney General's hospital room. There was the mad dash running up the stairs to try to beat White House counsel to the Attorney General's bedside. I think either Mullen or Comey testified it was the only time they'd ever used their sirens to try to get someplace fast, and it had kind of creepy third world overtones of people, rushing to get to the bedside of the stricken Attorney General before White House counsel could do mischievous things. So it was very significant when it ultimately came out. Do you recall what you knew that day or at the time that you were preparing the Attorney General's testimony.
That's a fair
Had those events taken place, and were you aware of them? Must have been the talk of the department if they'd happened.
Senator, fair question. And to my recollection sitting here, I found out about those things when everybody else did.
In
I was
the famous Schumer-Comey hearing.
whenever it came out publicly, Senator, I wasn't.
You weren't read into it, and you hadn't heard about the excitement in Attorney General Ashcroft's hospital room.
That's my recollection, Senator.
Okay. Very well. Thank you.
Thank you.
You're going to love hearing this, Mr. Chairman. I yield back my time.
I'll go with Sash. That's all right, Chairman.
I'm Grouch, so what the heck?
Judge, can we talk a little bit about the Ninth Amendment?
Absolutely.
It reads, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. What does that mean?
Well, Senator, I think it means what it says. The Ninth Amendment's not been much interpreted by the Supreme Court. There are different views about its effect and its meaning. And I don't doubt that there'll be cases and controversies in which I would, if confirmed, and maybe even if I'm not, asked to construe the meaning of that. It's one of those amendments that hasn't had a lot of judicial attention. We've talked about some others.
There's a publication in 1950 I read called The Forgotten Ninth Amendment.
Right.
So that's 60 years ago. It was forgotten then.
Senator Lee's written a book that includes some discussion of this as well.
Judge Bork referred to it one time as an ink blot, seemingly implying that it could just be ignored. Is there any precedent that we need to know about to understand the Ninth Amendment as it comes down through the courts?
There are amendments that have been less interpreted and more interpreted. The Ninth Amendment is one of those that has been less interpreted, Senator.
What's the best way to understand how the Constitution divides power between the federal government, the states, and the people? And in particular, how do we know whether or not some power that has not been specifically enumerated and given to the federal government, since the people give the government power, the government doesn't give us rights, the people gave the federal government certain enumerated powers. If it's not enumerated, how do we know if it belongs to the states or to the people?
Senator, we've talked a lot about federalism in this last few days. The people in this country are sovereign. As Lincoln said, it's a government by the people, for the people. So the people are sovereign. And it depends on what powers they've given to the state government and to the federal government. And there are variations between the states as to what authorities are given and how. Nebraska, you have a unicameral legislature last time I checked. I don't know if you're the only one.
We are.
Right? But that's the people have organized their state government in a certain fashion. And that's for the people to do.
But is there any precedent on the 10th Amendment that would give us some sense of what might belong to the domain of the Ninth?
So we do have precedent in the 10th Amendment area. I think the leading precedent might be the New York case by Justice O'Connor, which we've discussed a couple of times over the last couple of days, which makes clear that the federal government cannot commandeer state government, can't tell state government to enforce and how to enforce federal dictates unilaterally. Now, there's some, there are limits to that principle too. The 55-mile-an-hour speed limit, which is a federally induced requirement, has been upheld, attached to the spending authorities. There comes a question of how far Congress can go in conditioning funds before it winds up commandeering a state government.
I want to ask more questions about the ways that you would recommend that future hearings be conducted, but you won't answer. So instead, I will just agree with the senator from Rhode Island in commending the chairman on how he's run the last 3 days. Thank you, sir.
Thank you, Senator.
Senator Klobuchar.
Thank you very much. Thank you, Mr. Chairman. Thank you, Judge.
Thank you.
Mr. Chairman, you'll be excited. I'm going to mention one of your pieces of legislation here, so
Yeah.
it'll be good. I have been waiting for 2 days to talk about antitrust, but events of the day keep getting in the way in terms of what we've been focusing on. And I know that's to your chagrin since you have taught in the area. We've talked about this. You're an expert, as well as my counsel, Michael Cadis, who's been waiting months for this to happen, since he's an expert on antitrust. Senator Lee and I have long headed up that subcommittee, and we've been very active, a lot of hearings, and I think there's good reason to think that this could be a major area of the law ahead. We have seen people struggling to afford everything from prescription drugs to cable TV. And one way to help bring prices down, as you know, is to vigorously enforce our antitrust laws. Vigorous enforcement also fosters small business growth and reduces inequality and increases innovation. Obviously, if you have only two companies competing, you're going to have less of an incentive to be innovative. As we discussed in our meeting, tackling concentrations of power is a linchpin to a healthy economy and a democracy. And we are right now living through an unprecedented wave of mergers. Over the last 5 years, there was a 50% increase in mergers reviewed by the FTC and the Department of Justice. Just last year, then Assistant Attorney General for Antitrust Bill Baer, a lifelong antitrust practitioner, said his agency was reviewing deals with such serious antitrust concerns that they should never have made it out of the corporate boardroom. That's his quote. We also have a situation where the President of the United States, in a rather unprecedented move, commented about a major merger that is currently over at the Justice Department. And then in another major merger involving seed companies, actually met with the CEOs involved in that merger. And they came out of the meeting and said they talked about the merger. And these are just things that we have not seen happen since these mergers are supposed to be within the purview of the Justice Department. So you have taught a number of antitrust classes at the University of Colorado. And as you know, although the Supreme Court has not addressed the merits of a merger case in decades, recent court decisions such as Trinco, Credit Suisse, and Legion have made it more difficult to bring antitrust cases challenging anti-competitive conduct. Do you think the courts have made antitrust enforcement too difficult? What do you say to your classes about this specific issue?
Senator, thank you for bringing up antitrust. I can't count myself as an expert, but I can tell you it's an area I enjoyed practicing in very much. I represented plaintiffs as well as defendants. I represented class actions as well as defended against antitrust charges. I attempted, sometimes quite unsuccessfully, to interest the Department of Justice in attacking a merger or two for a client. You know what that business is like. When I teach antitrust, I try to teach everything about antitrust. I try not to take a view. I try to teach it in a Socratic method. I try to expose my students to the roots of our antitrust decisions, Appalachian Coal, what might be classified as the biggest bad school. Right? I try to expose them as well to the Chicago School, which, you're a graduate of the University of Chicago, and give them some sense of the economics that lie behind that. And then I try to expose them as well to more recent learning in this area and expose them to Professor Sunstein and his book Nudge. So I try not to take a view. I try to expose them to all views so they can make up their own minds. I believe that's an important function as a teacher, is not to be doctrinaire, but to be challenging. And I was very gratified the other day when I opened up the mail in my class, which I was teaching antitrust when all this happened. And I had said, they were very curious whether I was going to get the nomination. I said, it's not going to happen, but if it doesn't, I turn into a pumpkin, I'll have a friend step in to teach the rest of the semester. In the mail the other day, I got a tie with pumpkins on it.
There you go. Mm-hmm. So what do you see as the dangers to consumers and innovation if the courts make antitrust enforcement too difficult?
Well, The real problem at the end of the day, I mean, you have a problem of lack of competition between competitors. And then, of course, that filters down to the consumer level. And what that yields are higher prices and lower output, deadweight loss to the economy, loss of production. And those are real harms. And the antitrust laws, as you know, were the original federal regulatory regime. That was it for the national economy for a long time. And they're still vital and brilliant in their simplicity and design.
You know, one issue that's particularly important to me, and this gets into my bill with Senator Grassley, which I won't ask you to comment on. He's been very vigorous and done some great work in this area, is the pay-for-delay pharmaceutical agreements, where prescription drug companies actually pay generic drug companies to keep their cheaper drugs out of the market. These deals, in our view, can increase the cost of prescription drugs by billions of dollars a year. There's actually a CBO score on that. And until 2013, some courts had treated such agreements as per se legal. Then the Supreme Court, as you know, and FTC v. activists held that they were subject to the rule of reason. And I know you teach that case because it's on your antitrust syllabus. So what do you understand its reasoning and holding to be? And do you believe it was correctly decided? You may not want to go into that part, but how do you describe this case to your students?
Well, it's a great case. And as you'll recall, or at least as I remember it, because I do teach from it, and the year it came down, I had my students argue both sides, and half of them play the Supreme Court. And they correctly predicted the outcome. It was quite impressive. As I recall, one side was arguing for a per se unlawful rule. The other side was arguing for a per se lawful rule. And the Supreme Court, through Justice Breyer, as I seem to remember, who himself is an antitrust expert, said that the rule of reason applies, in part because we as courts, he said, hadn't had a lot of experience in this area and are very leery about making any per se rules, any bright line rules, until we have some experience. That's one lesson we've learned in antitrust law over the years, is to be cautious about per se rules, either direction, and before you have some experience, and that you can learn from the economics as you go.
Mm-hmm. As I was looking over that syllabus, I also noticed that you assigned both the 2008 DOJ report on monopolization and the FTC's response.
Yep.
As you know, this is a big debate. The FTC criticized the DOJ's report because the DOJ's guideline were too lenient on monopolization, would hurt consumers. That's their position. How do you teach this controversy, and which agency do you think had the better understanding of the law?
Senator, I teach it the same way as I teach the rest of the course, which is in a very Socratic method, and to try and expose my students to all the learning that I know of that's available. And it's quite a comprehensive course. I think it's considered one of the more difficult classes at the law school, or I hope it is. Mm-hmm. Now, federal courts may be even harder. I don't know.
So you don't want to weigh in on this debate?
Oh, Senator, there's no way you're going to get me.
All right. One last thing here. We live in an age where there are dominant internet companies in many areas which control access to customers. Internet search, social media, online travel are just a few examples. And Senator Lee and I both hear concerns in our role with the subcommittee that when such dominant platforms don't deal with potential competitors, their refusal can pose a serious threat to new businesses, consumers, and innovation. On refusals to deal as an antitrust violation, in the Novo case, you wrote, quote, "The point of the profit sacrifice test is to isolate conduct that has no possible efficiency justification." That principle is not explicitly in the Supreme Court cases. So is it your view that a refusal to deal can violate the Sherman Act only if there is no possible efficiency justification?
Senator, I'd have to go back and read what I wrote in Novell to give you a fair and honest answer to that question. But I can tell you in Novell, I was attempting to apply the Supreme Court's teaching in Trinco and Aspen Skiing, which are the two refusal to deal cases, as faithfully as I could. And I can tell you that. With 10th Circuit, we've had some fun refusal to deal cases over the years. Think about it. I mean, Aspen Skiing.
Yeah,
and
there you go.
Right?
Well, there may be more fun to come because, I think one of the things about using such an absolute test and risking immunizing the conduct, particularly in the context of the internet, could be a problem, because I think we have to look at what may be to come here, and we're just beginning to see a new kind of competitive marketplace with companies that may have control, and it may be really hard for new customers to get in. So that was just something I wanted to plant in your head here as we go forward, since you'll be, if you are confirmed, you have a lot of expertise in this antitrust area. And I just think we're just seeing more and more issues that are new and coming up, even in the last few years. And I know there hasn't been a case for a while, but there could well be one.
Appreciate that.
All right. So thank you very much.
Thank you.
I may skip ahead of Senator Franken.
Oh, that's okay, yeah.
Senator Lee.
Senator Lee?
Mr. Chairman? Mr. Chairman, before this is over, I would like to have one word to everyone. I don't know when's the appropriate moment before folks leave.
Well, maybe we ought to notify offices and tell people to come back.
Oh, gosh, no. No. I just want to say thank you.
Please.
Before people leave.
Why don't you do that right now and take as long as you want?
Does that mean I get to leave? No, I just know some people are walking out the door, and I just want to say this for the record, and if there's anybody left watching, I still want to catch them, the American people. I've spent the last, 2 months in these buildings with you, 72 of your colleagues. And I wish the American people could see what I've seen. That's all. I think if they had seen what I've seen, they'd be much bigger believers in their government than they are. It's not perfect. My branch isn't perfect. But I'm a believer in it. And I want to thank you, all of you, each and every one of you, for doing what you do for the American people, the seriousness with which you take this project. Mr. Chairman, for the courtesies you have all shown me, each and every one of you. Thank you. That's what I wanted to say before folks went home.
God bless you. Senator Lee.
Thank you, Judge, and thanks for your nice comments about our institution. We're not an institution that receives a lot of praise every day, and that means a lot.
You deserve a lot more than you get.
I wanted to cover one thing with you very briefly. One of my colleagues mentioned a few minutes ago an email that you had sent praising remarks by Judge, then Attorney General Alberto Gonzales back in 2006, February 6, 2006. I've got a copy of the transcript from that day. The remarks that you were supposedly praising were made and are recorded on page 53 of the transcript, which I offer into the record, and I also ask unanimous consent to offer those portions of the transcript and a copy of the email into the record.
Okay. Without objection, so ordered.
The comments that were the subject of that discussion, recorded on page 53 of the transcript, indicate that the committee took a break and reconvened after lunch at 1:45 p.m. on the date in question. The email, which I've offered into the record and which was sent by you on February 6, 2006 to Kyle Sampson and Will Michello, was sent at 1:17 p.m. Unless I'm missing something, that would indicate that your email, in which you said, I think the Attorney General is doing a nice job today, was sent roughly 1/2 hour before the comments that were deemed problematic by my colleague and were raised a few minutes ago. Do you, Judge Gorsuch, have the ability to see 30 minutes into the future?
Right now, I kind of wish I did.
I would find it very impressive if you did, but absent that very remote possibility, I would submit to my colleagues that it is impossible that the email that Judge Gorsuch sent on February 6, 2006 at 1:17 p.m. had any reference to the comments made reference to by my colleague from Rhode Island a few minutes ago. That is all. Thank you.
Thank you, Senator.
Thank you, Mr. Chairman. Thank you, Your Honor. And I want to thank my colleague, Senator Franken, for allowing me to go ahead. I have a speech to give with a colleague in the Capitol in a few minutes. I'd like to thank Luis and everyone else from your family and from your family of clerks and supporters who've steadfastly been with you through what's been, I know, a very demanding and long process. I think you've shown more diligence and more stamina than certainly I would have or many of our colleagues would have. I just want to conclude, if I could, a conversation that I opened in my second round of questioning about the Browder case, Browder versus Albuquerque. I didn't want to leave this unresolved. Because we had a long conversation about substantive due process, and I've made reference before to a practice you engage in of writing concurrences and sort of trying to understand what that means and what I can conclude about that. So just to remind everybody, Browder is a case where you dealt with a claim that a newly off-duty police officer went roaring through the center of town at 60 miles an hour, sped through 11 intersections with his lights on in his police car and rammed a car and killed one person and badly injured another. And this is a case that was in federal court because of Section 1983, which is an important statute that allows the vindication of rights that have been violated, constitutional rights. And I was struck in this case that you went out of your way to write a concurrence to your own majority opinion. And the way I read it was that you argued federal courts should decline to address Section 1983 violations if there's a remedy under state tort law. Why did you go out of your way to write a concurrence that would, if applied, significantly narrow federal courts' ability to consider valid constitutional claims? This was a case directly applying substantive due process analysis, and where you said, I don't think we ought to keep the doors of the federal courthouse open. I have familiarity with 1983 claims from my own county service and my role supervising a police department. It plays a central role in making sure that litigants who've suffered some loss or injury under color of state law have a chance to pursue a remedy. Why'd you write that concurrence, Judge?
Senator, I appreciate the opportunity to clarify the record on that, because I think there may be some confusion. I vindicated the 1983 claim in that case, as I have in many, many, many cases, Senator, if we want to pick them out. One here, one there. I could give you, for instance, Sutton, which we've talked about, or AM, we've talked about. Those are just a couple. I can give you a whole bunch more if you want. What I wrote separately to indicate was sometimes we judges judge best when we judge least. And if there is already a state tort claim that is perfectly suitable and can achieve everything that the plaintiff wants, and in fact, sometimes the plaintiff wants to be in state court but gets dragged, removed, I should say, that's the legal term, to federal court, okay? That happens not infrequently in my circuit in 1983 cases. There is a doctrine called Parrott, Supreme Court decision, that suggests that we should defer to state proceedings in those circumstances if they're perfectly adequate, fair, and complete remedies. And our precedent, I just pointed out, maybe we had missed Parrott, Supreme Court direction. I was bound by our precedent. I followed our precedent. But I suggested that perhaps we needed to take another look at our precedent in light of Parrott, the Supreme Court's direction. I also emphasized, to be clear, Senator, that Parrott only allows abstention in circumstances where the state remedy is full and complete and there's no possibility that the state court will be in an adequate forum. If you look carefully at that concurrence, you'll see that language there quite clearly and quite prominently, Senator.
And perhaps I misread it. In my consideration of it, I was struck by this in part because it seemed in Zimmerman there was already a 1990 Supreme Court decision that suggested Parrott shouldn't be applied in that way, in that context. But the larger point for me is that in Browder, you're suggesting the Supreme Court, you're pointing in the concurrence, you're pointing that the Supreme Court could overturn precedent to narrow the scope of 1983 in this way, to limit the situations where federal courts would hear constitutional claims. But in our conversation about RFRA and for-profit corporations and religious rights under Hobby Lobby, you pointed repeatedly saying that should be done by Congress. This is what the legislative branch should do, not what the court should do. So it seemed to me there was some tension between the way you looked at another situation where you issued a concurrence saying, I'm bound by precedent, but I don't like it, and I think we probably ought to make a change. Instead of pointing it our way, you pointed it at the direction of the Supreme Court. If you thought 1983 should be narrowed, why didn't you call on Congress to make that change?
Senator, respectfully, I believe you are misreading what I wrote. I wasn't advocating limiting 1983 in any way, shape, or form. I was suggesting that perhaps we, as a court, hadn't paid sufficient attention to the Supreme Court's direction in Parrott. That's it. And in all of these cases, I apply our precedent and the precedent of the United States Supreme Court and the directions of Congress as faithfully as I can, without any secret hidden agenda, Senator. None. And in Browder, I upheld the plaintiff's claim. That's what I did. That's my record.
That's
in
right.
that case.
The majority opinion which you wrote, which is a 3-judge opinion, upheld the claim. But I guess what drew it to my attention was your comments about substantive due process, and as we said before, 2 of them were Supreme Court sites.
Thank you for acknowledging that.
But that's a choice to say substantive due process, which is subject of some debate among scholars and justices, is uncharted, open-ended, murky, has a paradoxical name, substantive and due process. And I just wanted to come back again, because this is where we ended the previous round of questions, to see if I misunderstand how you interpret substantive due process. What are the factors that you look at? Because this goes back to the Casey and Glucksberg and others. What are the factors that you look at to determine whether a right is fundamental and appropriately protected under substantive due process under the 14th Amendment?
Senator, I look to precedent. And in the Browder case, I applied the precedent of our court, the Supreme Court of the United States, and our precedent indicated that the plaintiffs had a claim that should be vindicated, and I upheld the plaintiff's claim. There additionally was precedent from the United States Supreme Court that suggested that in circumstances where the state courts are open and available and there's no indication that there be any unfairness, that perhaps, sometimes, judges judge best when they judge least. Don't make more new law than you have to. That's a principle that I think good judges bear in mind when they can. That's not to say you always write the narrowest or crabbed or strictest construction. You try and come up with a fair construction. But that sometimes, if everything's available that might be made available to a party to be made whole, not to restrict their access in any way, shape, or form, Senator. But if everything can be done that can be done, then perhaps we should stay our hand once in a while.
Well, that's reassuring. As I suspect you well know, Section 1983 was originally enacted. It's been referred to casually as the Ku Klux Klan Act because it, in the Reconstruction era, was an avenue into state court to allow citizens who couldn't get any redress in state courts to get into federal courts, as a way to protect constitutional rights that were newly enacted after the Civil War. And it's one that, in my role as a county elected, where I was trying to monitor whether or not my police department, the police department of the county, for which I was indirectly responsible, was conducting themselves in full compliance with the rights of our citizens. One of those early indicators is how many 1983 filings do you see in any municipality, in any county. And I wanted to make sure I didn't misunderstand your ruling in Browder and your concurrence in particular as indicating some enthusiasm for narrowing access to federal courts for litigants. So if I hear you right, your concurrence, again, an unusual thing to do, to write a concurrence to your own unanimous majority opinion, is simply expressing that if you are confident that there is no threat to recovery in a state court, that someone injured, as the individual who was killed was, and her family member, should go to state court where tort law is fully developed and there's a great deal of precedent, rather than to federal court. But this is no suggestion on your part that constitutional rights don't belong in litigation. The transition point I made earlier was the 2005 article where you were suggesting some have too much enthusiasm for pursuing relief in the federal courts.
No, Senator, I think you now have a handle on where I was coming from. I appreciate the opportunity to clarify that. I think your summary right there at the end gets it.
Well, I'll have some more questions for the record, if I might. I appreciate the opportunity that I've had to meet with you and to ask a number of questions, and the seriousness with which you've taken my questions and the deliberations of this committee as a whole. Thank you very much.
Likewise, Senator.
I thought you said Cornyn. Oh, Crapo. Senator Crapo.
Well, thank you, Mr. Chairman. I'm going to simply say thank you, Judge, for giving us this time and for your candor with us as we have asked you questions. I'm not going to ask you any further questions, and will yield back my time.
Thank you, Senator.
Senator Franken.
Thank you, Mr. Chairman. And may I just add, with a number of my colleagues, my admiration for the way you've done this. Thank you. And Judge Gorsuch, for your family, your wife, and your clerks, and you for hanging in there. Before I begin, I'd like to ask consent that the following letters be entered into the record, Mr. Chairman. The Leadership Conference on Civil and Human Rights, Bend the Arc Jewish Action, and the National Education Association.
Those three documents without objection will be entered.
Thank you, Mr. Chairman. Judge, during oral arguments for Shelby County, Justice Scalia seemed to suggest that it's the court's job to step in when Congress's motives can't be trusted. Justice Scalia questioned the significant rise in support for the Voting Rights Act when Congress voted for its reauthorization in 2006, which passed the Senate 98-0 and the House 390-33. He essentially said that a senator would have nothing to gain by voting against reauthorizing the Voting Rights Act, and that, as a result, the court should not read anything into the overwhelming support for the bill. Justice Scalia said, and I quote, "It's a concern that this is not the kind of question you can leave to Congress," end quote. He went on to say, quote, "Even the name of it is wonderful, the Voting Rights Act. Who is going to vote against that in the future?" When the Solicitor General suggested that it would be unusual to analyze Congress's judgment in this way, Justice Scalia said, and again, quote, "I'm not talking about dismissing it," meaning Congress's judgment. "I'm talking about looking at it to see whether it makes any sense," end quote. So he is suggesting that the court look at Congress's judgment to see whether it makes sense. Now, this highlights two things that are pretty concerning to me. One, Justice Scalia's cynicism about lawmakers' motives. His remarks demonstrate a contempt for Congress that, in my view, also demonstrates a willingness to engage in the kind of judicial activism that many of my colleagues are quick to condemn. A willingness to, quote, unquote, legislate from the bench. Justice Scalia's willingness to reach beyond the legislative history to question Congress's political motivations disrespects the separation of powers. And two, Justice Scalia's remarks ignored the facts. When Congress debated reauthorizing the Voting Rights Act of 2006, it developed a significant legislative record. 15,000 pages of hearing testimony, documentary evidence and appendices, state records and reports from outside experts that demonstrated the continued need for the legislation. To suggest Congress's support for the bill was based on anything other than substance ignores the reality that more members of Congress supported the Voting Rights Act because the legislation accomplished on an ongoing basis exactly what Congress designed the Voting Rights Act to accomplish. Judge Gorsuch, during our courtesy visit, I asked what you thought about Justice Scalia's remarks, and I asked you whether you agreed that what he said demonstrated a contempt for Congress. You emphatically said that Justice Scalia's remarks were not the words that you would have chosen.
Senator, I admire Justice Scalia greatly, but his words are his words and mine are mine. And I ask you respectfully to judge me based on my credentials and my record. Justice Scalia's legacy will live on a lot longer than mine, I'm sure.
I understand that, but it was good to hear that you wouldn't have said that, but I found that frustrating because it wasn't the answer to my question. Here, despite a unanimous Senate vote in support of the Voting Rights Act and a 15,000-page legislative record demonstrating that there was a significant debate over the bill, Justice Scalia questioned Congress's motives in deciding to support the bill. It seems to me that he is substituting his own personal views for the facts on in the record. Do you agree a willingness to engage in this kind of speculation could be perceived as judicial activism?
Senator, respectfully, I just don't think it's appropriate for me to comment on the work of my superiors or Justice Scalia's words at oral argument or any other justice's comments.
Well, I think that it's important, this issue of judicial activism, because that's something that's disturbed me about the Roberts Court. And this is one of the big decisions, which is the Voting Rights Act. But setting aside that was a 5-4 decision. I want to know whether you, forgetting judicial activism, I want to know if you agree with the substance here. Justice Scalia seemed to be reaching beyond legislative history in this case to question the political motivations underlying congressional action. In your view, is that kind of inquiry appropriate for courts to engage in?
And Senator, again, I just don't think it's appropriate for me to sit here and grade a justice's comments at oral argument. Judges,
okay. All right.
Judges often ask questions at oral argument that are hypothetical or don't represent their actual views because they're testing ideas.
Okay, well,
I wasn't there. I didn't hear it. I'm not going to condemn a man for arguments I haven't heard or thought carefully about or know more about. And Justice Scalia's legacy will live on a lot longer than mine. I'm confident
let's move on to the Shelby decision itself. We talked about this at the courtesy visit. This was another 5-4 decision by the Roberts Court. Here, the court gutted the Voting Rights Act. Before that decision, the act required certain states with a history of engaging in discriminatory practices at the polls to get the federal government's approval before making changes to their voting laws. It was called preclearance, and it worked. Within 4 years of passing the Voting Rights Act in 1965, nearly 1 million black voters registered, and the number of black elected officials in the South more than doubled. But the Shelby County majority suggested that discrimination at the polls was no longer a problem, essentially using the law's success at preventing discrimination to justify gutting it. So a sharply divided court, again 5-4, that's important, struck down a provision that determined which states were subject to preclearance. As a result, none of them are. In the wake of that decision, states previously covered by preclearance started testing the limits of what they could do. Texas and North Carolina passed discriminatory voter ID laws. North Carolina eliminated same-day registration and cut the early voting period. When North Carolina's restrictions were challenged in court, the Fourth Circuit ultimately struck them down, finding that the state's, quote, new provisions target African Americans with almost surgical precision. You mentioned that Section 2 of the Act was still in place when we were talking before, which allows discriminatory laws to be challenged, but only after they've been enacted. So I pointed out that North Carolina, for example, enacted its surgically precise restrictions in 2013, but the Fourth Circuit wasn't able to strike down those restrictions until 2016. So these restrictions were in place for years, and these restrictions accomplished exactly what they were designed to do when they kept African Americans from voting in the 2014 election. But these restrictions would have been stopped by pre-clearance. We talked about this, and I asked you, does this disturb you at all? You replied simply that equal protection of the law was one of our country's great promises, but you didn't answer my question. We went around the barn a few times on this one. You told me that voting is a fundamental right. I know that. This is a job interview. You are applying for a lifetime appointment to the highest court in the land, and vindicating the rights of people before the bench is one of the core functions of that job. So knowing whether you are disturbed by a state's government's effort to systematically and strategically discriminate against its citizens by race is really, really important. And it seemed like an easy question to me, so I'll ask you again, does that disturb you at all? What happened?
Senator, if there are allegations of racism in legislation in the voting arena, there are a variety of remedies. The first, of course, is a claim under the Constitution and the equal protection.
There used to be pre-clearance, and that used to do the job. And again, this is a 5-4 decision. This is what we're talking about here. I want to emphasize why we're here and why all of this matters so much. Some of us on this side of the aisle have been accused of asking unfair questions, of impugning judges, of essentially turning this into a show, apparently because we are bitter about what happened to Chief Judge Garland. And yes, I strongly believe that what happened to Merrick Garland was unfair and disgraceful. The argument that we should judge and are judging candidates solely based on their qualifications is betrayed by the fact that these are the same people who blocked Merrick Garland, and Merrick Garland has every qualification. He is a man who is recognized as one of the best appellate judges in this country, in large part because he's developed a reputation for bringing judges across the ideological spectrum together to craft strong consensus decisions. So yes, I was looking forward to his nomination moving forward, but I don't blame you, Judge Gorsuch, for what happened to him. And ultimately, this isn't about Judge Garland. If Justice Scalia had died 1 month ago, and we were here today with President Trump's nominee, we would be talking about the same things. I think I and all my colleagues have asked tough but fair questions about your record, about your judicial philosophy, and about your ability to understand the practical outcomes of these decisions. And it's because we are deeply concerned about the Roberts Court's, what the Roberts Court's rulings have done for the rights of Americans. In one 5-4 decision after another, we have seen the Roberts Court go out of its way to answer questions not before it, to overturn precedents, to strike down laws enacted by Congress, and to do all of this at great cost to consumers, workers, small businesses, to middle-class Americans, to those who don't own a car and don't have a driver's license. So it's harder for them to vote. We talked about forced arbitration. Through a series of 5-4 decisions, the Roberts Court has eroded Americans' ability to seek justice in the courts when they've been cheated or mistreated by a corporation with vast resources. We talked about voting rights. Shelby, another 5-4 decision. The court gutted a key provision of the Voting Rights Act and with it suppressed African American votes. That's what it did. And in Citizens United, also 5-4, the Roberts Court allowed money to pour into our elections. We don't know where a lot of it is coming from, and it's eroding Americans' trust in our most fundamental democratic institutions. And the public thinks it stinks, Republicans and Democrats alike. That is why we are here. This is about people getting to court. About people getting to vote. This is about people losing, Americans losing faith in our democracy. So while I strongly agree that it is your job to follow precedent, as you have emphasized over and over again, I also want to know that you will consider the real-world consequences of your decisions because the stakes are just too high. I want to know that you understand why we have been here and why we have been asking you the questions. Because, and I think Senator Whitehouse spoke very, very clearly on all these 5-4 decisions. And I just want to hear from you that you understand what the stakes of this are.
Senator, I appreciate the opportunity. I don't know.
No, please answer, and then,
Then I'm done.
Make it as short as you can.
I can do that. We're all in the same boat together. The ship, we're all in it. And either we're all going to hang together or we're going to hang separately, to mix my metaphors at this late hour. And the fact of the matter is, Senator, of course I care about this country. I care deeply about this country, and I know you do too. Thank you.
Senator Cornyn.
Judge, let me offer an alternative point of view to my friend Senator Franken's dystopian description of where the country is and the role of the court. I'm particularly concerned about his description of the court's decision in Shelby County versus Holder, because I was part of the Senate Judiciary Committee, a number of us were, when we voted to reaffirm the Voting Rights Act, to reauthorize it, and recognized it as one of the great accomplishments of America in terms of protecting and vindicating the rights of people, everyone, to vote. But as you know, Congress didn't, and the Supreme Court did not gut the Voting Rights Act. Section 2 remains a part of that important historic legislation. And so I just recoil when I hear people describe what the court did as gutting the Voting Rights Act. Here's what the court did. Congress, when it reauthorized the Voting Rights Act, did not update the formula by which the Section 5 applied, which would require pre-clearance in states, so they couldn't even change their own voting laws because they were covered by pre-clearance. They had to ask permission of the federal government, the Department of Justice, and other, in order to do so. But for some reason, rather than update the formula with current voting records, it had decades-old, several decades-old voting information, which had an impact of keeping more states and more municipalities, more governmental entities within the pre-clearance requirements of Section 5. The irony of this is the Voting Rights Act has vindicated and protected voting rights in an unprecedented sort of way. And even those states that had been swept up into the pre-clearance requirements, let's say back in the 60s, had better outcomes for minority voters than many states that were not covered by Section 5, the preclearance requirement. So the mistake that Congress made when it reauthorized the Voting Rights Act is it included a formula that did not reflect current reality, did not recognize that America had made great strides forward thanks to the Voting Rights Act in vindicating minority voter rights. So I was here. I remember the debate. Matter of fact, I joined several of my colleagues and filed minority views when we reauthorized it, pointing out the irony of using decades-old voting records in reauthorizing the Voting Rights Act. So what the court said, the question actually presented, I'll read it quickly. It says, does the renewal of Section 5 of the Voting Rights Act, the preclearance requirement, under the constraints of Section 4B, that was the formula I referred to, exceed Congress's authority under the 14th and 15th Amendments and therefore violate the 10th Amendment and Article 4 of the Constitution? That's what the court decided. The Voting Rights Act maintains its force and important role in our jurisprudence today, and the court found that the formula simply did not reflect current reality when passed and exceeded Congress's authority under the Constitution. I mention all this not to ask you a question, but just to use the opportunity to say, you know, when people agree with the court's decisions, and I can bet I can name a number of them that my friend from Minnesota would agree with and applaud. You know, it's great when the court reaches a decision that disappoints your expectations or perhaps your political agenda, then it's easy to jump on the court and criticize it. Nobody likes to lose in a court, but I think you appropriately earlier talked about the importance of not criticizing or characterizing the judges, because judges by and large are patriots, people performing a public service at great financial sacrifice, and unfortunately sometimes get accused of doing things that are totally unfair and off base. So I just wanted to take a moment to correct the record and what the court actually did. And I happen to come from a state, the state of Texas, that's proud of the strides that we have made to overcome the record back in the 60s when we weren't so proud. We shouldn't have been so proud about minority voting rights. But we've made great strides in that area, as have so many places that were covered by the Voting Rights Act under Section 4, which the court struck down as not reflecting current reality. We should stand up and applaud our great country for trying to overcome this legacy of diminishing minority voting rights, and I think the court's decision is something that reflects that and is to be applauded and not condemned. So thank you for sitting there and listening. Thank you for your willingness to serve, and thank you for the way you've conducted yourself throughout this hearing. Look forward to enjoying and watching from afar your service to our country for many years to come. Thank you.
Thank you for your service, Senator.
Senator Blumenthal.
Thanks, Mr. Chairman. I would like to enter into the record, if there's no objection, a letter from 55 reproductive rights, health, and justice organizations opposed to the nomination, and a letter from 72 women lawyers who submitted an amicus brief in Whole Women's Health v. Hellerstedt.
Both will be entered in a record without objection.
Judge, you referred at some point, I think, to your clerks as evanescent. I think you used that word, but I think many of them are still here. So they have been far from evanescent in this proceeding.
They've been wonderful, as has my family.
And congratulations to them and to you and to your clerks.
Thank you.
I met a couple of them earlier who said that, and I'm not going to embarrass them by naming them, but one of them said that he had left his employment with a law firm to help you prepare for this proceeding. So they've been part of your team. Who else has helped you prepare?
First and foremost, my wife, Louise, who has been with me through thick and thin. When the gruel is thin, the gruel is thick, she's there. She's my rock. I also have to thank Senator Ayotte, my Sherpa. I didn't know that was an official title, but it is around here. I really appreciate this opportunity. Senator Ayotte, I didn't know Senator Ayotte until the day after my nomination, well, the day of my nomination, February 1st, which would have been my father's 80th birthday. And he smiled on me that day because he gave me Senator Ayotte. And I don't know how many miles we've logged walking the halls together, meeting with you and your colleagues, but she's become a fast and permanent friend. Where's Mary Elizabeth? Mary Elizabeth, who was in your Republican Senate cloakroom and is now in the White House. She's been just so special to me.
Anyone else from the White House?
Oh, gosh. McGinley here? He's one of my former law clerks, who's now a young lawyer in the White House. And I never thought I'd actually have somebody carry my bag. And it's way...
I never thought I'd carry a bag after graduating law school.
And I feel very guilty about it because this is a very fantastic young lawyer. Watch out for McGinley.
Anyone from the Department of Justice?
Oh, gosh. Who's here from the department? A lot of, well, a whole bunch of folks.
So you've been well prepared.
Well, Patrick Bumate, Eric Tung, one of my former law clerks, one of Judge Timkovich's former law clerks who are now in the Department of Justice, have been helpful, as I know, to produce all those documents. I think they spent a lot of time reviewing and producing documents for this committee and all of them. So there have been a lot of special people in my life.
I'd be remiss if I failed to ask whether anyone from outside organizations has assisted in this process.
I've definitely had friends, beat me up with questions and things like that. Absolutely, Senator. Sure. Of course.
And has anyone from, for example, the Heritage Foundation helped you prepare?
I don't know who's from Heritage. No one's come up to me and said, I'm from the Heritage Foundation and I'm here to help. I've definitely leaned on my friends, Senator, and I've leaned on people from the Department of Justice and the White House counsel's office, my
and
family.
Former clerks.
And former, yeah, yes, yeah. And current clerks, too.
I have a couple of substantive questions for you.
All right.
No right is absolute under the Constitution. Is that a correct statement?
Well, Justice Black used to think so.
He said no law, and he said no law meant no law, limiting free speech.
Yes.
But in fact, rights frequently conflict, and there's a balancing that takes place, correct?
Senator, there are always tensions in the law that we mediate as legislators and judges, and the executive branch all play a role in mediating tensions between competing rights.
I want to talk a little bit about, in that context, the Second Amendment and about the decision in Heller. You undoubtedly know that Connecticut experienced one of the most significant tragedies in our history when a massacre occurred at Sandy Hook. I have long been an advocate of common sense, sensible measures to combat gun violence, going back to my earliest days as State Attorney General. And my colleagues, many of them, including Senator Feinstein, who mentioned Sandy Hook here, and Senator Durbin, have been champions of this measure, these kinds of measures. And I mention the balance of rights because that was a theme that Justice Scalia mentioned in Heller. He wrote that the Second Amendment is, quote, not a right to keep and carry any weapon whatsoever in any manner whatsoever for any purpose. That I would read as a statement that the Second Amendment is not absolute. Would you agree?
Senator, I would agree that in Heller, the court held that it protected guns in common use, for example, not every weapon or tank or ballistic missile, but guns in common use for self-defense, subject to reasonable regulation. That's my recollection sitting here of more or less the test the court.
Well, I'll give you the quote, and I think it confirms your recollection. He said that the Second Amendment did not include, quote, dangerous and unusual weapons, end quote, such as, quote, weapons that are most useful in military service, M16 rifles, and the like, end quote. Do you agree?
Senator, the law is the law. It's the press of the United States Supreme Court. I follow the press of the United States Supreme Court as a judge. It's the same answer I've given.
Well, let me again ask you about another part of the Heller opinion. Justice Scalia wrote, quote, he said, nothing in Heller was, quote, intended to cast doubt on longstanding prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and public and government buildings, or imposing conditions and qualifications on the commercial sale of arms. Do you agree with that approach?
Senator, I agree that Heller is the law of the land and that it's precedent of the United States Supreme Court. And it's the obligation of judges to apply precedent of the United States Supreme Court.
So it's a correct statement of the law.
If you've read from Heller, Heller is the law.
And do you believe it's a correct interpretation of the Second Amendment?
Well, Senator, it is the controlling interpretation of the Second Amendment. As I indicated maybe yesterday or maybe it was today, I don't know. We've spoken about Heller so many times. But I think both the dissent and the majority opinion were very fine opinions and very thoughtful, if you want to use a term, originalist opinions. Justice Stevens in dissent, Justice Scalia in the majority. Very thoughtful, detailed look at the original public meaning of the Second Amendment. They came to different conclusions, as judges sometimes do in hard cases. But I think that's a wonderful case to look at and say there are judges doing admirable work of judges who might have reached different conclusions, some of them, if they were acting as legislators and voting on their preferences rather than trying to interpret a law.
But the basic idea of conditions imposed on that right, no right being absolute, public safety being a legitimate consideration, is one with which you would agree.
Well, Senator, one example I remember sitting here in Heller is the felon in possession statute, which I recall the court specifically mentioned, and the dispossession of felons, which is a law that we administer regularly in the courts.
And in fact, a panel of your court, 10th Circuit, has held that the Second Amendment does not provide the right to carry a concealed firearm. That's Peterson versus Martinez. You weren't on the panel, but it was the holding of your court, correct?
I think that's right, sitting here, but I'd want to go reread it.
I have the opinion with me if you
Senator, I trust your representation.
And you didn't, no one requested a rehearing in that case, so if you had disagreed with it, you could have requested a rehearing.
Any judge can, as we've discussed,
Right.
request a rehearing sua sponte. Yes.
Correct. You know, I asked about your preparation because I think you've been very adroit in answering many of my questions. And as adept as you have been, I remain troubled because you have been less forthcoming, less direct and specific than I hoped on whether you agree with the conclusions and results in some of those cases. And I think you probably sense my worry or unhappiness about some of those answers. And I understand that your approach is that there could be cases and controversies involving these decisions, but you've left doubt. And the doubt is increased because of statements made by the president who nominated you, that he was, in fact, choosing someone who would, for example, automatically overrule Roe v. Wade. And so I have felt that you had a responsibility to be, if anything, more forthcoming than judges or justices nominated in the past. You were fairly clear in your answer on Brown that you thought it, quote, corrected an erroneous decision, and that it was, quote, a correct application of the law of precedent. But you gave a different answer on Loving, Griswold, Lawrence, Eisenstadt, Obergefell. You said these cases were decisions of the court. You informed us of the holding, but you were unwilling to say that they were correctly decided. And judges or justices in the past, and I named some, were more forthcoming, direct, specific, saying they agreed. They thought those decisions were correctly decided. So I remain troubled. And I'm troubled because these doubts affect real lives and real people. Gay and lesbian Americans have to wonder whether Lawrence and Obergefell might be overturned or whether you would vote that way. Americans will lack the confidence that Griswold and Eisenstadt will be upheld. They have to question whether they'll be able to make their own reproductive decisions. Millions and millions of women who have apprehensions about Roe v. Wade and whether you would vote to overturn it will find very little basis for confidence in what you have said about those decisions. And I began by saying that I was looking for core beliefs. Your response was that your personal beliefs have nothing to do with decisions that you will make. But we know that core beliefs matter, just as words matter. And the distinctions that you've used in describing different cases matter. The great genius of our Constitution is that it grows to match the challenges of different times. The great genius of the Supreme Court, in my view, and of many justices, is that they grow too. And I have seen it firsthand in the justice I worked for, Justice Blackmun. You may have seen it in your brethren on the bench much more directly and closely than I. So we can't anticipate with precision and certainty what justices will do once they are appointed for a lifetime on the nation's highest court. But the American people hold us on this panel accountable for making our best judgments based on all the information we can glean or elicit. And so that's why I've probed as hard as I can for your beliefs, your commitments. I think they matter. And I want to thank you for being here and sharing with us your ideas to the extent you have, and say that I will be submitting more written questions as well, and I will reserve my own judgment until I have the chance to assess your responses to them and the responses that you've given us over the past 3 days. Thank you very much, Judge. Thank you, Mr. Chairman.
Senator Graham. Thank you very much, Mr. Chairman. Judge, I think we're getting toward the end here, and I only have one request, that I never hear about the fish case again. for the rest of my life and yours. Because if I do, we will defund the court. I hate that case. So,
A great case.
yeah, that's your opinion.
I make all of my potential law clerks read it.
I know. That's why the Geneva Convention should apply to them. But, so let's just say this. Sonia Sotomayor and Elena Kagan have served their nation well, honorably, and they have not grown, in my view, the way I would like them to have grown. I don't expect them to decide the cases the way I would have. Now, growing means you got to agree with me, I guess. I know they're not going to all of a sudden change your judicial philosophy because the general counsel to, who was the guy? To Obama? What was his name? Yeah, Greg Craig said that Elena Kagan is progressive in the image of Obama himself. He didn't grow a lot, in my view, in terms of his liberal philosophy. And I don't think these two justices have served the country poorly by not coming my way. I just think they haven't grown in terms of understanding the conservative view of being a judge. But they're qualified, and they sit on the court today, and I understand that. As to Judge Garland, dear man, fine man, I don't think anything happened here on our watch that is anything unusual. When you look at the last 100 years, I think you've had one situation where in the last year of a presidency, a vacancy was filled when it came open in the last year by a president of one party and a Senate of another. And to my friends on the other side, if you think I believe you would have done something differently, I don't. I don't. Here's what my friend Joe Biden, who I talked to today, by the way, as chairman of the committee, said in June 25th, 1992, when there was a potential opening in the last year of Bush 41's presidency. He said it would be our pragmatic conclusion that once the political season is underway, and it is, action on a Supreme Court nomination must be put off until after the election campaign is over. If someone steps down, I would highly recommend the president not name someone and not send a name up. If Bush did send someone up, I would ask the Senate to seriously consider not having a hearing on that nominee. We agree, Joe. We got your message. Here's what Harry Reid said in 2005. The duties of the United States Senate are set forth in the Constitution of the United States. Nowhere in that document does it say the Senate has a duty to give presidential nominee a vote. Here's what Senator Schumer said before the American Constitution Society. We should reverse the presumption of confirmation. We should not confirm any Bush nominee to the Supreme Court except in extraordinary circumstances. That was in his last year, so it's not very persuasive to me. Here's what I would say, that if an opening occurs in the fourth year of President Trump's term and the political season's afoot, that I'll be with y'all if you say wait till the next election. That's the one thing I can say. You like president? We just created one. And I think we'll be bound by it, and Joe Biden was going to do it back in 92, and y'all would have sure on the other foot. We'd have wait till the election was over. And why are we here? Because Trump got 306 electoral votes. That's why we're here. That's why you're nominated and not somebody else. Because I didn't expect Donald Trump to pick Merrick Garland, even though he's a fine person. I expected him to pick from a list of 21, which he told the whole country before the election, here's my list. Now, the one thing you can say about President Trump, when it came to the Supreme Court, he showed his cards. It was really unprecedented. And he kept his word, and he chose from that list all highly qualified, and I, honest to God, can't think of anybody I would have chosen above you. I ran for president. It lasted about 30 minutes. I enjoyed the entire process. I was apparently the only one, but if I would have won, I would have chosen you too. So, but I think the bottom line is that you're highly qualified from the conservative point of view, that the last 10 years have been a testament to good, solid judging. You've stood out in all the right ways as a judge. You've conducted yourself honorably, and to expect a Republican to pick someone like you would be very much expected. And I'm happy he did, because I'll be honest with you, I was worried he wouldn't. But now we've got a great nominee, and I hope we can get you over the line here. I want to ask you about a case that nobody else will ask you about: polygamy. Not that I'm advocating it, I want to get that straight. But the decision, Obergefell, is that how you say it?
Obergefell.
Okay. The Justice Kennedy, the Roberts Court, decided that the Due Process and Equal Protection Clause of the 14th Amendment guarantee the right of same-sex couples to marry, and that is the law, right?
Yes, Senator.
Is it possible 3 people could fall in love and want to marry? Are there places in the world where polygamy is the practice?
Senator, there are places in the 10th Circuit.
But it's illegal in America, isn't it?
Senator, we just had a challenge to Utah's
But the law of Colorado says it's illegal.
It does.
Is there any state in the Union that recognizes polygamy as a legal marital relationship that you know of?
At the moment, to my knowledge, no.
So the point is that apparently as a nation, we're all okay with not extending marriage to 3 people. One day, we may not be okay with that. One day, maybe we want to broaden our view of what marriage should be. And that day may come, and you may be the judge. And I guess what I'm saying is to Senator Blumenthal, rather than pledge allegiance to all these cases, you should treat them for the presidential value they have. And maybe one day, 3 people will argue that we love each other as much as you love your wife or a same-sex couple. I don't know if that day will ever come, but if it doesn't come through the political process, the only venue for somebody to challenge would be the court. So in terms of Griswold, if you can't figure out what you're saying, you're not listening very well. I think what you're saying is if there's ever an effort to overturn Griswold, it will mature as a case in controversy. I think you've been very honest with us. I can't imagine a situation anywhere in America where some politician would try to change the law in this regard. And I can't imagine the court hearing that case. But if that ever happened, I'm glad you're willing to say, I will at least listen. And for you to do more than that would, I believe, run afoul of what Justice Ginsburg said. A judge sworn to decide impartially can offer no forecast, no hints, or that would show not only disregard for the specifics of the particular case, it would display disdain for the entire judicial process. As to Justice Roberts saying, I like Griswold, that is certainly his right. I don't know if he tipped his hand, but I can say this. If you're listening to this man, this judge, I think he recognizes the real-world consequences of overturning that decision and that you will apply the law. But if there's ever a case before you that challenges Griswold, I'm glad to hear that you're going to listen. As to these other cases, I promise you there will be legislative efforts to protect the unborn. And some of them may have a different legal theory than Roe v. Wade. Some of them may run into the construct of Roe v. Wade. I'm glad you're willing to listen to those of us on this side of the issue. As to same-sex marriage, I've been asked a lot at home to introduce a constitutional amendment to overturn the decision. I've decided not to do that because I think it would put the country through something that's not going to bear fruit. But to the people who believe that traditional marriage should be protected and oppose same-sex marriage, I don't think you're all crazy. I think many of you have religious views. But the court has ruled. And I don't know if the court will ever decide that 3 people can get married. But I hope that the judges who hear that case one day, if it ever comes, will at least do what you promised to do. Listen. Base the decision on the law, should it change, and the facts of that particular case. So the bottom line here, Judge, is that you cannot give the answers that the other side would like, because what they want you to do is make sure that they can go and tell everybody he's okay with all the cases we like. The Roberts Court is interesting. When they upheld the Obamacare Act twice, I got accused of owning Justice Roberts because I voted for him. Actually, I don't really disagree with his rulings. I'm a bit surprised by it. When Justice Kennedy decided that same-sex couples can marry and state statutes have to fall, the Roberts Court wasn't very popular over here. All I can say about the Roberts Court, it's made up of some pretty incredible people. And his time will come and his time will go. And if you get to be part of that court, I think Donald Trump will have done a good service for the people of the United States. Because what he will have done is chosen one of the most qualified people I have ever met in my time in the Senate or otherwise. Someone who's endured 2 days of very difficult questioning, shown an understanding of the law that amazes me, has lived a life that I can only compliment you on. And as to President Trump, whatever differences we have when it comes to this nomination, you did the country a great service. To my colleagues, I know it is tough right now. If this man doesn't get 60 votes, then I don't believe we can ever find a Republican in the country, presidential pick, that would get 60 votes. There's nobody I know better in my world, the conservative world, than this man. And I hope and pray that you will honor President Trump's selection as I chose to honor Sotomayor and Kagan. Whether they're better qualified, I'll let other people decide, but I'll fight to the death to say that you're equally qualified. Thank you very much, and Godspeed.
Thank you, Senator.
Thank you, Mr. Chairman. Judge Gorsuch, you have sat through many hours under the cameras and under the lights over the last 3 days, and that goes for all the people who are sitting there who have been supportive of you. And for all that, many of my colleagues across the aisle particularly have called it an endurance test, granted. But Judge, the real endurance test is about the struggles facing working families, women, people of color, the LGBTQ community, immigrants, and Native peoples. It's about the struggles that everyday Americans have and face. These are the people who will be impacted by the decisions you would make on the Supreme Court. These are the people for whom the need for justice is often most urgent. These are the people I'm focused on when I consider your nomination and any nomination to the Supreme Court. It remains to be seen if you will be a justice for all or a justice for some. Over the last few days, you have often told us about what counts and what does not in terms of what a justice should do and how we should assess your nomination. When other senators and I have asked about your opinions in specific cases like that involving the terrible choice facing Alphonse Madden between freezing or being fired, you have told us to look at your whole record. When we asked about decisions where you seem to adopt strained interpretations that narrowed laws meant to protect worker safety, you said you are a judge and don't take sides. And that if the statute was too limited, Congress should do better. When we asked about your decision in Hobby Lobby, which found an expansive new right to religious liberty for a corporation that employs 32,000 people, you did not explain how you assessed the terrible impact this decision had for thousands of women who would now be denied access to health care. During my last round of questions, I asked you about your understanding of the influence of politics on the composition of the court based on your 2005 article, Liberals and Lawsuits. It was not an attempt at a gotcha moment or to paint you in an unfair light. It was an attempt to get to the reality that both you and I understand. I wonder how you would approach the kind of tough cases that reach the Supreme Court and how, say, a Justice Garland would approach the same case. I think there would be a big difference. We know that Justice Scalia and Justice Ginsburg, both legendary jurists and close friends, would reach dramatically different results in cases that matter deeply in the lives of millions. Cases like Shelby County, Lilly Ledbetter, Hobby Lobby, Roe v. Wade. Donald Trump knew this too when he set forth his very clear litmus test for a Supreme Court pick. He said he wanted a justice who, for example, would adhere to a broad view of the Second Amendment and who would overturn Roe v. Wade, to quote him, automatically. Your article in 2005 made clear you know judicial philosophy matters. Of course it does. That is why we are so focused on understanding your judicial philosophy and getting beyond platitudes about the judicial role. That is why this confirmation process matters. This is serious business. That is why we still have questions. That is why I remain concerned. Judge Gorsuch, over and over again, you have told us to focus on your whole record as a judge and not certain cases or certain of your writings and books or articles or emails. In fact, my Republican colleagues suggest we are being unfair to try to look to those things to discern how you would approach cases if confirmed. Some have even gone so far as to conflate the questions we are raising about your record in the course of our advice and consent responsibilities with Donald Trump's abhorrent attacks on federal judges. Attacks like the one on Judge Watson of Hawaii, which he repeated last night at a $30 million fundraiser for congressional Republicans. Apples and oranges doesn't begin to describe the differences between what Donald Trump said and what we are seeking to do here. Although I wasn't in the Senate, I recall during Justice Sotomayor's confirmation hearing that Republican after Republican ignored almost the entirety of her nearly 25 years on the federal bench. Instead, they focused and question after question on a gross misreading of one speech she gave to a group of young women about the value of diversity on the bench. Many of them cited that speech to justify their opposition to her nomination. Judge Gorsuch, was that a fair basis on which to evaluate Justice Sotomayor's nomination?
What was a speech that she gave a fair basis on which to judge?
Yes, we have been criticized for focusing on some very important cases to try to get to your heart, your judicial philosophy. Meanwhile, Justice Sotomayor was judged by some of my colleagues based on one speech, and I'm asking you whether that was a fair basis on which to judge her nomination.
Senator, I've declined to offer personal opinions about cases, and I've also declined to offer personal opinions about the advice and consent function of the Senate. That's your constitutional responsibility and this body's, and it would be presumptuous of me as a judge at once to say I like or dislike the work of the United States Supreme Court as a lower court judge, and it would be presumptuous of me as a judge to say I like or dislike how this body discharges its constitutional obligations. That's really your judgment.
Excuse me, you have consistently asked us to look at your whole record. That is why I asked the question. You have said again and again in these hearings that you cannot provide your views on specific precedents, but at times you have done that. You have praised the Youngstown case. You have criticized Korematsu. You have praised the Brown decision. You said that Cruzon and Glucksberg were rightly decided. So how can you express these opinions but refuse to provide your views on Casey, Hiller, Roe, Citizens United, Griswold, Gideon, Ledbetter, Groves, University of Texas, Southern Medical Center cases?
Senator, I've offered my legal judgment as a judge about cases. I've not offered any personal views about anything, or I've tried not to very hard. I've tried to adhere to Justice Ginsburg's rule about no hints, no previews, no forecasts, Justice Scalia, Justice Souter, Justice O'Connor, and all the judges who come before me, and I've tried not to break the chain.
You did lend your support, however, to some precedents and not others, so thus the question. You have told us also several times that judges make terrible legislators. You told us that courts lack the staff, capacity, and training to do the kinds of fact-finding that is an essential part of the legislative process. And in that context, I do want to return briefly to Shelby County and the Voting Rights Act. When Congress reauthorized the key expiring provisions of the landmark VRA in 2006, it did so with a nearly unanimous vote. And before reauthorizing the protection of Section 5, in jurisdictions with a long history of discrimination in voting, this committee alone held 9 hearings on the VRA. The thousands of pages of material the Senate reviewed, together with the record developed in a dozen hearings in the House, clearly established a continuing need for Section 5. And yet, in Shelby County, the Roberts Court ignored this evidence, and the court's long precedent made its own determination about the value of the extensive evidence reviewed by Congress. It struck down those provisions. So much for judicial modesty, so much for balls and strikes, so much for judges judge best when they judge least, which you mentioned tonight as a virtue. So, Judge Gorsuch, does the Shelby County decision raise the kind of concerns you have noted about the limits of judges as policymakers and the problems that arise when a court steps outside of the judicial role and acts as a legislative body?
Senator, Shelby County is a precedent of the United States Supreme Court. I'm not here to disparage the work of the United States Supreme Court.
Both the process and the outcome in the Shelby County case raise exactly the kind of concerns that make it so important for us on the committee and in the Senate to understand your judicial philosophy. We are, after all, talking about a lifetime appointment to the highest court in the land. And after the obstacles to voting we have seen since Shelby County, we now know that Congress got it right, that the evidence showed a continuing need for Section 5 of the Voting Rights Act, and the Supreme Court got it wrong when it substituted its judgment. So once again, I'm asking this in a different way, and, well, give it a shot. Judge Gorsuch, doesn't the outcome of the court's action in striking down Shelby County suggest you have it right when you point to the limits of judges as legislators?
Senator, what I would say is after Shelby County, there remains some remedial mechanisms available to individuals concerned about voting rights. There's always an equal protection claim under the United States Constitution. There also is a Section 2 claim available to anyone who's concerned. It goes beyond the Constitution. And should Congress wish to legislate, the court in Shelby County made clear that it could do so with more updated formula for preclearance. So that remains a remedial regime possibility as well.
The real-life impact of the Shelby County decision was that 13 states passed laws that could be deemed voter suppression laws, including the first state was Texas, which intentionally passed a discriminatory law. So I think everyone understood the ramifications and the import of that particular decision. And we learned in that decision that it matters a great deal for our rights. What is the judicial philosophy, or as my colleague Senator Blumenthal would put it, core beliefs of the judges who serve on the Supreme Court? If judicial philosophy developed through life experiences, education, etc., and that judges should apply instead precedent, why would we have so many 5-4 decisions in critical cases? Judge Gorsuch, I wish that I could say that this hearing has been illuminating for what was said by you. Instead, I'm left to judge your nomination largely on the basis of what you refuse to say. Mr. Chairman, I yield the rest of my time.
Tell us, and Senator Kennedy will be the last two, so whenever you finish, the judge will be able to go. I may have a few remarks at the tail end. So it's up to you guys.
Thank you, Mr. Chair. Just briefly, without objection, I'd like to enter some other letters that come from a diverse group of people attesting to Judge Gorsuch's qualifications and balance on the bench and in law practice.
Without objection, they will be entered.
I'm going to be brief and yield back 10 minutes of my time. First, I've heard the sort of messaging today about the Roberts Court. We've already heard from Lindsey Graham, whose comments I'd like to be associated with. The Roberts Court has produced Massachusetts versus EPA, not something that on my side of the aisle that was very popular. Arizona versus the United States, the National Federation of Independent Businesses case upholding Affordable Care Act, another case with the EPA, the Utility Air versus EPA, King v. Burwell, Young versus United Parcel Service, Williams-Yulee versus Florida Bar, and Overfeld. It seems to me that we've got folks down on the other side of the street here that do a pretty good job of being objective and following the law. So I'm not so sure this branding that they're trying to come up with, or that some are trying to come up with on the so-called Roberts Court, has a lot of weight on matters of major substance, not to mention the multitude of judgments that they make over there that we don't even talk about. I want to talk a little bit about history and then just thank the judge for his contribution. But I have to go back to some numbers, and I want to call out, that there are folks here who have already laid the groundwork for a filibuster, for trying to hold up the confirmation of an enormously well-qualified judge to go onto the Supreme Court. But I think when you criticize Judge Gorsuch, you're really criticizing, because of the numbers, the entire 10th Circuit. 97% of the time, unanimous decisions. He is in the majority of decisions, which he participates 99% of the time. So I would assume the concerns that you would have for Judge Gorsuch, you would probably have to be intellectually honest, place those same concerns with anybody coming out, whether they're a Democrat or a Republican judge on the bench or put forth by a Democrat or Republican administration. I also think that requiring a supermajority for someone, a lot of people have used history here to suggest that maybe requiring a supermajority is the norm. It couldn't be any further from the truth. Republicans did not require a cloture vote. They didn't seek a supermajority for Justice Ginsburg, Justice Breyer, Justice Sotomayor, or Justice Kagan. And I would believe that if we apply the same mainstream standard that seems to be being created here, maybe things would be very different on the bench. For example, I don't think most Americans think mainstream is to propose abolishing Mother's Day, to suggest that there's possibly a constitutional right to prostitution, or to urge the establishment of co-ed prisons. Yet those views were espoused by Ruth Bader Ginsburg. They're certainly controversial today. I suspect they were when Ruth Bader Ginsburg was before this committee. But they didn't require a special standard, and they actually voted for a confirmation. As a matter of fact, she was voted in 96-3. Now we'll move to nominations under the Obama administration. I submit most people wouldn't find mainstream to believe a person of one ethnicity or gender would reach a better conclusion than a person of a different ethnicity or gender. I bet they wouldn't think it's appropriate for a judge that's appearing here that would say impartiality is an aspiration. But those were the views that Justice Sotomayor did when she came before this committee. Her quotes, things that were in the public view. I would hope that a wise Latina woman would more often than not reach a better conclusion than a white male. The aspiration to impartiality is just that, an aspiration. This is somebody who got voted to be a Supreme Court justice. And we didn't set a different standard. As a matter of fact, the only way that Justice Sotomayor was confirmed was through the support of Republicans. They could have filibustered it. If the speaker at the time or the minority leader at the time had gotten up, if the majority leader here had tried to convince us or convince the members who were here at the time, we could have held up this new standard. It simply doesn't exist. Doesn't exist, I don't think, in the tenure of any of the senators on this committee. So the question is, are we just creating a new set of rules? And are we doing that at our own peril? Is this the new norm? Is this how we're going to run this process? This is the first time I've been through it. It's only happened 112 times in the history of the United States. This is the 113th. Are we really going to set that standard? Because it's not a standard that's really existed in history, but that's what we're on the brink of doing. And I will tell you, we could end up a slippery slope that won't work out well for this institution, and I don't think it will work out well for the Supreme Court. You know, we had a 63 to 37 vote for Kagan, in spite of her comments defending that maybe court should have the authority to outlaw a pamphlet that could have been a modern-day equivalent to common sense. In Sotomayor's case, 9 Republicans, of which Senator Graham was a part, voted for Sotomayor, and in spite of the comments that I just mentioned. I really think we ought to go back, listen to what the judges said today and yesterday and the day before, and recognize we have an extraordinarily well-qualified jurist before us who will do a great job on the Supreme Court. And Judge Gorsuch, I want to apologize for some of the people here who I know you're a very kind person and a kind soul. You said there were no inappropriate questions. I, for one, think there were a lot. But I'm not going to ask you to respond to that. I'm just going to thank you for your kindness. I'm going to thank you for your energy. I want to thank you for your resolve. And I want to thank you for having an impeccable record that builds a compelling case for you to be the next Supreme Court Justice on the Supreme Court. I wish you the very best. I'm going to keep you in my prayers, and I look forward to voting for your confirmation. Now I yield back the remainder of my time.
Thank you, Senator.
Senator Kennedy.
Thank you, Mr. Chairman. Judge, I join my colleagues in thanking you for your answers. I think they were as candid as you could make them under the rules. And I appreciate all the time you spent preparing for this hearing. I also join my colleagues in thanking your family, especially your partner. This is a tough business sometimes, and it's especially difficult on families. You have quite an extended family as well. I've spoken casually with some of your law clerks, and they're very devoted to you, and that speaks volumes to me. I want to thank Senator Ayotte for her wise counsel and advice. I have 2 quick questions and then a request, but I can't let go unaddressed some of the comments made by my friend from Minnesota about the Voting Rights Act. I'm from the South. The Voting Rights Act, we were the subject of the Voting Rights Act. And I can say that I guess this is sort of a glass half full or glass half empty sort of thing, but this country has gone from institutionalized slavery to an African-American president in 150 years, which in the grand scheme of life, death, and the resurrection is not that long. And I'm very proud of that. I didn't agree with our first African-American president on all of his positions, but I'm very proud of the fact that this country made that kind of progress, and I just wanted to say that for the record. My first question, I don't know whether you've picked it up from my questions and comments or not, but I have what I think is a healthy skepticism about government. I believe I do have a right to privacy, and part of my right to privacy is to be left alone by government sometimes. That doesn't mean that we don't need government and that I don't have confidence in government, but I think there should be limits to government. And I think the United States Congress sets those limits. Do you agree with me that our United States Constitution is a document of enumerated powers and that neither the federal government nor any of its branches have a power unless you can point specifically to a place in the United States Constitution that gives them that power?
Yes, Senator.
Thank you. It's been my experience, and this I was taught, that justice is supposed to be blind. I realize that's a cliche, but cliches become cliches because they're true. Do you agree with me that the wealth, the status, and the power of the parties to litigation should have absolutely nothing to do with the result in the litigation?
Senator, I take an oath written by this Congress. It's a beautiful oath. It's to administer justice without respect to persons, to be blind to who they are, and also to do equal right to the poor and to the rich, and to administer the duties of my office, to discharge them impartially. I've tried to do that here to the best of my abilities. Not perfect. Tried to do it for the last 10 and a half years as a federal judge. Not perfectly. But that's what I try to do each and every day, and it's a great privilege and a great honor to be able to do it. And I'm humbled. I'm honored every day I come to work. And I've been humbled and honored to be here with you.
And I believe you'll do that in the United States Supreme Court. My final statement is not a question, it's a request. It seems to me that justice is kind of like health care. It's not really accessible unless you can afford it. And I'm very concerned about the cost of litigation in America and the fact that it has affected access to our courts. It's just become so expensive that many of our people can't afford to have their day in court. And I know administratively the federal judiciary has some powers, and I hope once you're on the court you'll talk to your colleagues and see if you can put your thinking caps on and do what you can to try to control the costs of litigation. With that, I thank you again. I thank you, Mr. Chairman. I'm sorry my iPad went off, but it won't happen again.
I have a few words to say, but before I say those to you, Judge, we're going to reconvene tomorrow morning at 9:30 when we'll hear from outside witnesses. So before I let you go, I think that you've demonstrated a great deal of patience, and that's probably necessary to get the votes of the United States Senate. You probably can't show you ever get mad, but boy, you had to be disgusted sometimes, but you didn't show it. I know you aren't, but that's kind of the way I would feel if I were in your shoes. I suppose the thing that bothers me most about a lot of the questions you got, you seem to agree with so many people that we're trying to get a yes or no out of you, and they didn't seem to want to take a yes for an answer even if you didn't say yes, because you kept saying, I don't know how many times, maybe hundreds of times, it's the law, it's the precedent, and how you're going to approach those things. There ought to be a great deal of satisfaction on people that we got somebody that says the law means something, what the people's elected representatives pass means something, and within our system of judicial interpretation of law and the Constitution, that precedent plays a very important part, and that we have a document that's going to bring certainty, and that certainty is based upon, as it was laid out by our forefathers, to make sure we had stability and predictability in our public policies. So evidently it didn't frustrate you, but I want you to know it frustrated me that they wouldn't take really, in a sense, a yes for an answer even if you didn't answer in a three-letter word. I think you should know that I'm very impressed with the way you handled all this testimony. For the last 3 days, the American people have witnessed a very impressive command of the law. most surely the thoughtfulness that you put into everything you do, particularly how you responded to our questions. And that can only come from the discipline that you've given yourself as a judge already on the 10th Circuit. And it pretty well ought to demonstrate to everybody how you're going to handle when you get to the Supreme Court of the United States. So I think you're to be commended for your strength in this enduring process. And I think that the American people witness, most importantly, a person that has a great deal of humility. And I think it shines through in not only your own nonverbal demeanor, but also in what you say. So I thank you very much for being a good witness. Thank you very much for your public service. And the meeting's adjourned and you're excused.
Thank you, Mr. Chair.
The spirit behind the purpose of the Constitution, and in the final analysis, that's going to play a big role, but that's always modified by precedent of the Supreme Court, and it's obviously been modified several times by amendment to the Constitution. So how he approaches the law, whether he uses strict constructionists or whether you don't have any adjectives whatsoever, I think he shows you that he's a thoughtful person who's going to do what judges are supposed to do, judge law and not make law. And as far as I'm concerned, that makes him a strict constructionist. He doesn't have to use the word. You can call him anything you want to, but people that stick to their job under the Constitution of adjudicating and not legislating, that's what I want out of people on the Supreme Court.
Senator Tillis made a comment that some Democrats during this hearing were kind of laying the groundwork for a filibuster. Are you expecting Democrats to filibuster this confirmation?
I don't think. I think they're going to have to realize the way this person performs and he does what judges are supposed to do, it's going to be pretty hard for them to mount a filibuster. And would they want to mount a filibuster with the results that could result from such a filibuster? That I think they want to save the 60 votes for the next vacancy on the Supreme Court.
Chuck Schumer says that if it came to a nuclear option, that Mitch McConnell doesn't have the votes probably on the Republican side. What do you say to that?
I would say to them, let's take a day at a time. I just got done telling this lady that I don't think that they're going to want to change the 60-vote rule and save that for a future time.
Senator Blumenthal mentioned judges' preparation and asked specifically about whether or not anyone from the Heritage Foundation or others were prepping him. How much of the details of his preparation are you aware of? Do you know who was all involved in preparing him for
No, he named them there, and I wouldn't have been able to name one of them.
Senator, do you agree with Senator Graham about if he doesn't get 60 votes, no Republican president could nominate somebody that would get 60 votes? And do you think that
you could nominate somebody like Kagan and get 60 votes,
but a Republican president might not?
No, that's right.
So you do agree?
Well, if I agree with him, though, that means that someday you're only going to have 5 or 6 people on the Supreme Court. We aren't going to let that happen, and the people aren't going to let that happen.
Right. I mean, it does indicate a increasing polarization, I guess, in the Senate when it comes to Supreme Court. I mean, there's not a 97-0 or 98-0 like Scalia anymore.
But we had Bork and then we had Thomas, and then there was 10 or 15 years where you got a Breyer and a Ginsburg and 90-10 votes, and maybe that can return, and this guy might help return it. His performance today ought to get a little people to reconsider what ought to go into the selection or the approval or disapproval of a nominee to the Supreme Court.
Thanks, Senator.
Thank you.
The Senate Judiciary Committee has completed day 3 of its questioning of Judge Neil Gorsuch, nominated by President Donald Trump to fill the 9th seat on the Supreme Court. Judge Gorsuch has undergone about 20 hours of questioning so far, and the confirmation hearing will continue tomorrow when the committee hears from witnesses who support and oppose his nomination. We'll have live coverage here on C-SPAN 3 beginning at 9:30 a.m. Eastern Time. Committee Chair Senator Chuck Grassley is planning to vote the nomination out of committee on Monday, April 3rd, hoping for Senate floor action before its Easter recess begins April 7th. A reminder, all of this week's hearings coverage, plus related briefings and programs, is available at cspan.org. Type Neil Gorsuch in the search box.